అందరికీ శుభోదయం. గుడ్ మార్నింగ్ టు all of you. Welcome to Legal Matters by Sai Babu Sankar. This is an insurance case or consumer protection case wherein Honorable Supreme Court of India held that the insurance company cannot repudiate the claim in the case of a boiler explosion that the condition of the boiler was not informed to the insurance company at the time of issuing the policy. Caveat emptor, whose duty it is to see that the boiler is in condition or not, for the insurance company. But you all know the principle behind insurance, Uber, Rima, fides, or Uber, Rima, fides, in good faith. Normally, they do it in good faith. But when problems come, Supreme Court will ask like this only. You should have checked it before. Now you can't say that these people did not inform the condition of the boiler. In the case of Kopargaon Sahakari Karkhana Limited, Kopargaon. So whenever you visit Shirdi, you will be coming about this village, Kopargaon. Famous village. Kopargaon Sahakari Karkhana Limited. Production of sugar is very much there. Versus National Insurance Company Limited. SLP number 1317 by 2022. Decided on 13th November 2025 by two judges bench. Honorable Justice Pamadi Ghantam Sri Narasimha and Manoj Mishra. Wherein the bench held that the insurance company cannot repudiate, saying that damage was discovered only after the policy was issued. The appeal was allowed and they have to pay the compensation. Basically, what for insurance? Insurance is to protect the people from unexpected events like this explosion. Right. This Kopargaon Sahakari Karkhana, they have taken the policy or they have obtained the policy of insurance for about 1.6 crores damage. The policy is effective from 1/2/2005. 1/2/2005 నుండి 31/1/2006 వరకు. The risk covered is damage or loss up to 1.6 crores. So తీసుకున్నటువంటి 5 monthsకి, that is on 12/5, 3 monthsకి, 12/5/2005, there was a blast or explosion that took place and the boiler exploded. There is insurance company, they have appointed a private surveyor to explore the area to assess the cause and also the damage, loss. But the surveyor reported that it is due to the leakage of tubes to the boiler which were fitted in the year 1986 and no maintenance so far. Because of the tubes because of that bulging, the tubes have become loose and actually corrosion was there. Corrosion, tubes ki tuppupatni. The tubes were expanded as a result of which the blasting has taken place. So igniting trouble undagane actual ga reason for the explosion is this one in Japan. So therefore definitely they have written a letter to the Sahakari Corporation, Sahakari Karkhana, stating that we are sorry, we are repudiating the claim because you have not maintained the boiler properly, you have not fitted the tubes. Right? So therefore, they approached the State Consumer Dispute Resolution Council. Of course, they have actually, these people claimed a compensation of around 87 lakhs. SCDRC ordered payment compensation of 48 lakhs. This insurance company went to the Honorable Supreme Court of India in appeal. Right. Of course, luckily, Actually, NCDRC, first they went to NCDRC. NCDRC also, actually they allowed that the compensation need not be paid because the blasting has taken place due to the negligence, due to the non-maintenance. Now they came to the Supreme Court. Honorable Supreme Court of India, please remember, they have dealt with extensively on exclusion cause number 5. ఇది ఏంటంటే Uber rima fides. If the defects are not stated at the time of insurance by the so-called sahakari corporation, definitely it can be repudiated. Kani boilers inspection will be conducted by the boiler inspector. I think every year they will be conducting the boiler inspection. Of course, inspections ఎలా ఉంటాయో మనకు తెలుసు, but when once the certificate is given, we have to assume that at least they are in condition. ఏమీ లేకుండా మరీ అన్యాయంగా రాయరుగా అని మీరు అనుకోవాలి. స్కూల్ బస్సులు చూస్తూ ఉంటారు కదా, స్కూల్ బస్సులు యాక్సిడెంట్ అయిన తర్వాతనే చూస్తుంటారు స్కూల్ బస్సులో ఎన్ని ఇల్లీగాలిటీస్ ఉంటాయో, సరే వైలేషన్స్ ఉంటాయో చూడాలి. అట్లా ఇక్కడ కూడా జరుగుతుంది. బట్ వాట్ ఎవర్ ఇట్ ఈస్, సుప్రీం కోర్ట్ సెడ్ దట్ వెన్ ది బాయిలర్ ఇన్స్పెక్టర్ సెడ్ దట్ ఇట్ ఈస్ గుడ్ కండిషన్, హౌ కెన్ యూ సే దట్ ఇట్ ఈస్ డ్యూ టు ది లీకేజ్ ఆఫ్ ది సో కాల్డ్ ట్యూబ్స్? సో ఇన్సూరెన్స్ కంపెనీ కెనాట్ ఎస్కేప్ ఫ్రమ్ లయబిలిటీ బై సేయింగ్ లైక్ దిస్. He is saying that the tubes are of 1986, they were not maintained, they were not fraudulent. And please remember, the company or sahakari corporation, they have given the details. Fittings when were done, these people did not ask. If you don't ask, akkade inko point kuda chepparu. If you do not put the same in the pleadings, ee defense meru tubes were fitted 96 iyanni ee pleadings lo raayala. So entire CPC's adversarial system, you don't ask, how can you claim arguments with చెప్పగలరు అని చెప్పి, in the absence of pleadings and evidence, so no conclusion can be drawn. NCDRC judgment is set aside, and once again NCDRC will look into the compensation matter. Supreme Court ఇంత అని చెప్పలేదు కానీ అప్పీల్ అలౌ చేస్తూ అడ్మిట్ చేసుకో. Very good judgment on behalf of the Sarkari Corporation, Sahakari Corporation. Read it and definitely you will be enriched with the legal knowledge. Thank you.